Okay, 4:30, call to order. We all stand for the pledge. Pledge of allegiance
To the flag of the United States and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The minutes have been recorded, and then I turn it over to you for old business.
So we have two policies on for old business. One was student publications, IGBB, that we went back after we had some initial conversations with the ACLU, and then I know you reached out to them as well. And they still had some concerns about that. So that's one of them. We want to take a look at that. Does everybody have a packet that wants a packet? Would you like one, Ryan?
Yes.
Would you like one as well?
Nothing. Looks like this extra one.
Yeah.
Thank you.
So some of the information, if you look at the digital copy up here, you can see some of the red information. That was after our attorney had looked at it and simplified a lot of the stuff that we had originally. And that is according to, and Michelle, maybe you want to go ahead and kind of talk about what some of the concerns are, or if there are any other concerns.
Well, I guess so according to, ACLU, they said we were violating First Amendment rights of the students. They should be able to say whatever they want to say. It was kind of kicked back to say, like, well, we don't want to be discriminatory, we don't want to hate, so we want to kind of do that. And they basically still fired back, saying we're still taking away the amendment. So Andrew 3 times tried to get us to where we could find like a happy medium, and they're still calling us out saying we're still violating First Amendment rights. So I don't know how to push this forward.
In the information that you shared, if this is okay, there were a couple of areas that I could see maybe some wiggle room. The one that I think we have wiggle room on is where it talks about distribution of literature. We don't really define what that means. And looking at some other policies in other districts, it did look like there were a little bit more for examples of that. So we could see maybe that could be more explicit. There was a comment where it says the new language in the latest draft policy, such as requiring the expression of opinions differing from the publishers, it seems to them inappropriately intrudes on the editorial independence prescribed by the statute. But as I found that, I didn't understand where they thought that was a problem, because the way I'm reading it, and I didn't remember which paragraph that was in. So I think it's on the second page, underneath the red part. The expression of personal opinion must be clearly identified as such. Opportunities for the expression of opinions differing from those of the student publishers must be provided. In addition, the student newspaper and other publications which are paid for by the school district, produced under the direction of a teacher as part of the school curriculum, are not considered a public forum. In such cases, the district reserves the right. I think that's where they're talking about, and I don't see how that's a violation. I feel like we're saying that we are giving them the right to do that, except in some cases where in school we can oversee some of the.
It sounds like it's in some cases
Okay.
that they're like,
So maybe
they
that's
should have this freedom to say whatever they want to say. What have we done in the past?
Well, I actually was in charge of the Tollgate newspaper for a number of years. And when it was in its printed form, I did let kids write editorials. Anything, they wanted to write, but they were not allowed to use profanity or put in something that would cause, like bullying or harm someone else. And
Very logical.
And I allowed them to, especially when GBP started up, it was very controversial. It still is. It's annoying. It's another story. But I allowed the kids a free reign of printing all their opinions about this new graduation by proficiency and whatever, and I had somebody say to me, this has to be the most anti-tollgate newspaper, and I'm like, the kids' opinion. So, but nothing in there was going to cause anyone harm. So I'm not a lawyer and I'm not a
Right.
member of the ACLU, but I think this language covers what we do in school.
And I feel like from looking at some of the other policies, you know how he has numbered these final 4 down here, those are in line with exactly what we won't allow, you know? So I think to your point, Darlene, that's, you know, libelous, slanderous, unwarranted, warranted invasion of privacy, those things. I feel like that's what covers us and differs for schools. I know we can't tell them that they can't have freedom of speech. That's not what we're saying, but there is some order that they have to, you know, maintain.
Well, it's the classic, you can't yell fire in a crowded theater. So there are already limits to what people can say. And since many publications are now digital and online, you could provide all sorts of links to things that wouldn't pass muster in a regular school day. So I don't know. I personally don't see a problem with the way it's written. If, under the distribution of literature, if we need to define what we mean by literature.
So interestingly enough, like the one I was looking at, it was very specific about non-school publications.
Can I send you all of them or just the last one?
No, yeah, just this one for the Title IX. I was doing my own little research.
No, yeah, the conversation between.
Oh, no, I only got one. That's all. So, you know, I know we talk a lot about the yearbook and the newspapers, but I guess this is a protection about, you know, just any student being able to pass out pamphlets or whatever. And do we have to define non-school or school? I don't know. That's kind of another, do we have to get into that? Or do we just name some of the typical things that we would see? Newspaper, yearbook, maybe just say non-school materials. I don't know.
I mean, right now, going back to senior project, students sometimes do distribute flyers for when they are doing their collecting for some organization or having a fundraiser or having some kind of event to bring awareness to some kind of, you know, disease or whatever they're up to. So they are distributing non-school literature. It's stuff that they've created that they are distributing.
Yeah.
Or maybe during class elections or whatever, their election, you know, they make posters and they might pass stuff out. So I can see that being
Yeah, and I'm thinking of all those great examples, like all of the research they might be doing that might, you know, for their project or whatever it is, but at the same time, it kind of comes back to those 4. We're not allowing them to, you know, cause a huge disruption and
Right, and it's ensuring that it's not defaming someone, it's, you know, because every student is entitled to a safe and secure learning environment
Right.
that is not disrupted with precedent, so I don't see how that would be an infringement upon freedom of speech when we're spelling it out like under those provisions. I think it's clearly defined. The only thing I would say is we might want to, like, going back to the student publications, like what is a school versus non-school publication?
Well, I guess, can I read this to you? What her exact response was? As you know from reviewing the state statute, the major goal of the law is to provide students with the independence to express themselves in school publications with very limited administrative oversight. The statute sets out the particular expectations to that independence, and we believe schools do not have the power to expand them. Thus, the new language in the latest draft policies, such as requiring the expression of opinions differing from the publishers, inappropriately intrudes on the editorial independence prescribed by the statute. This is highlighted by the fact that the proposed policy refers to both violations of it and the state law. The new language governing the distribution of literature also raises concern. First Amendment standards generally require a substantial distribution of the educational process, and in the absence of any definitions, it is unclear what literature would require advanced submission, was her response.
That one you did send me, yes, yep. So that's why I was thinking that I could see, like, we could probably get into that if we want to make some adjustments there and.
So the second sentence of
Yeah,
the
this part was in conflict with the statute as well, but so what I would, the second sentence of the next paragraph, so students' First Amendment rights to freedom of expression and equal protection of the law will be observed in regard to student publications, whether school sponsored or non-school sponsored. Is that what she's referring to? She doesn't name it, but that's, and I'm saying she, I don't know. But
The observance of these rights must be balanced against the duty of educating students in an orderly manner to protect the rights of all. So did she have an objection to that?
and it doesn't really describe, she just says the second sentence of the second sentence of the next paragraph. I'm sorry, I read the first one.
So is that the word?
Yeah, that must be it. In order to protect the rights of all. And again, I know her job is to really not have any limitation to speech, but I think as a school district, we do have a responsibility in some cases to kind of
Sure.
say, we have to be careful about those four things, right?
Mm.
So we may not be in agreement, but this committee might be okay with passing this to the school committee to see, but would you like us to spend some time to dig into the distribution of literature or something
I think-
like that?
I mean, I understand, I can think at this point that they want open.
Yeah.
Where I understand as a school, as admins, you, like, we can't completely do that. I guess, I mean, however, we can close the gap as much as possible.
So suggestions? Distribution of literature, we could say, we could put in, do we need to put school? I feel like it's only non-school, because if it's school, would it be a problem if it's a project that they're working on? I guess it potentially could be.
Could fall under some student could possibly be in violation of the 1, 2, 3, 4 previous
right.
for school work.
So maybe school-related literature.
So we didn't change much from the original, right?
From the very original, it looks like,
Because why didn't they have a problem with the original? And then,
yeah, it looks like more of what was added was this top part. And then did the original, you guys would have to tell me, have 1 through 8? Or was that something, it has underlining, so I'm assuming that it was added. All student publications will comply.
I do not remember.
Yeah, I feel like that looks like it would have been added if it's underlined. And then, like I said, our attorney had simplified it. All right,
We have to go back to some earlier
yeah,
printed policy manual to find it because the online stuff has been updated frequently over the years. Or some frequently, some infrequently. Like this one was adopted in 1998 and then not revised.
not revised. Yeah. All right, so question, I don't want to be too long on this. If we need to table it and do more work on it, around defining those 2 areas, that's fine. We can move on from that, but just please tell me what you would like. Would you like it to be school-related literature versus, because there's plenty of examples of that.
But then when you spell out what if something else is not
I know.
listed, then it
And that is the difficult part about policy is they want it to be specific but broad at the same time, where we're not
Right.
locking ourselves into every left. We don't know what will happen, digital versus non-digital.
I guess what it comes down to too is something where we can find like a medium where, we can kick back and say like, there's no way we're going to satisfy
Yeah.
100% of the First Amendment, without having to worry about the other aspect of the bullying, like, Whatever.
Yeah. Yeah, I mean, I would have thought this was pretty good to go. Like after even reading this, I really felt like I don't see the problem with, but
I
it's
was,
up to us.
I was expecting her to be like, okay, this is much better.
Right, it's not happening. All right, so I would like to ask next steps from you guys. What would you like to see happen? Committee?
I say bring it back to the school committee for a first read.
Yeah.
Yeah.
And see if it passes as is. What does it?
So then what should we change?
Because they're gonna ask me if the ACL approve this, I'm gonna say no. And then he's gonna be like, well, why is it on the table?
Do we have, I mean,
With the ACL, you have to approve every school committee
because I
decision.
don't think that's how it works.
Works, yeah.
I think it's just more about not wanting to be in violation of any codes of stepping on anyone's First Amendment.
I understand that, but I also would say as a committee, this is our job to decide what goes forward. So if, I mean, I know you're predicting it might get pushed back, but that's fine, if it goes back. But I'd rather hear from all of you, like, that's just one opinion. You're thinking it won't go through, but do we go ahead and at least send it to the
School
first
committee
reading?
has its own legal counsel as well that reviews all of these
Right.
policies. So, if they were under the belief that it was in violation of, some freedom of speech, we would know that, like, before the meeting. I think it should go in front of the school committee.
Yeah.
And then it's up to our legal counsel to assure everybody whether or not it's in violation of anything.
Well, then in that case, then I'd rather just hold it and do an email with Andrew and then have him guarantee that portion of it before we put it out.
So I'm asking him if this still stands,
Yeah,
even though he just wrote it.
even forward it, be like, this is what they said.
Yeah, forward him.
Okay.
the-
Well, I said,
Oh, that one. Okay. Yeah, sure. All right, let's do that then.
And see if there's something he can phrase
Differently then. Okay, so the second one, another one that was tabled was our Title IX. Some of you might not have this. Michelle had given me a copy of Westerly's Public Schools grievance procedure. Thank you. That's easier. Just as an example to compare, the one thing that I would say about that we're looking at, and we just got it, like even Michelle and I really didn't get time to really thoroughly look at it, but it's dated as August 2022 as their last update. And we know that this new policy was pushed out and has to be in effect on August 1st. So of this spring. So that's my only wonder is if that is the most current, and they may have.
Right, might need to be updated, which then I probably would have to reach out to them. This is just what I found on their website.
So can we talk about, like, we talked about that in this committee, sending it forward, but then it got tabled. And I'd like to figure out where we stand with it so we know what to do next.
We are definitely tabling this, because I want to see Westerly and compare it, because apparently Westerly did a really good job at making it fair across the board. But unfortunately, I don't see what the difference, like, you're right, it's 22, I don't see what was supposedly, I was told what was written about it.
Well, that's what I'm trying to figure out, like, we can take a few minutes and look at it to see how it really adds, or, is different than the one that they gave us as a template.
And somebody sent me the article where it looks like the Supreme Court argued it down that it could not be federally regulated.
So I don't know about that, but we did have a training on Title IX with our attorney on the first few days back, and he has kept us informed that, we can certainly have an injunction by a school, not specifically an entire district, so a school can do that. And so in that case, we would just be using the older Title IX when we have that complaint brought to us. But in the meantime, you know, it was sort of a go in terms of like, we should be moving forward, but if there is an injunction, we would use the older version. So I guess we're at this point where we gotta figure out what are we bringing forward? What's the problem with it? What do we see as the issue?
That it's not completely equal, it's not equal. There's no equality. It's just kind of across the board. It's just saying, like, we're just kind of blanketing everything. And that's why I want to see Wesley, how I was told that the way that they worded it was a little bit better. But I wanted to make sure if we're gonna follow policy, it is fair across the board. And that everyone is safe and equal.
But this is specifically around sexual harassment, right? We know that. That's the Title IX. This is
Right.
specifically about putting more definition and explicit language around the protections of expanding sexual harassment.
Right. But there's more to it. And like I said, I don't feel comfortable passing this forward until I find out what Wesley wrote and seeing the differences.
Would you like to then not look at it right now, but take your time to look
For
at it
sure.
and bring it back?
Right, and I was hoping that we could hear and talk about the two different here.
Yeah, we can do that.
This is not even anything. And I've reached out to say, where's the other one
Okay.
that was read by the other school committee person, but have not gone back to me yet.
Okay.
But I was told specifically to compare what Wesley wrote. They said that Wesley did a really good job at writing their own.
Who said that? Who said that Westerly did a good job?
Public and another fellow community school committee member.
Was another Warwick School Committee member? And just some members of the public?
Yes, correct. And I thought,
So
we
I
should get
don't-
one of those.
I guess to your point about the equality piece, if that's what we're looking at, because a lot of the other procedural stuff is procedural stuff that we have in there. We have to give supportive measures, you know, some of those
Right.
things. Complaints, we don't have to do a formal complaint anymore. It can be by, you know, verbally expressing that.
Yeah.
So that seems outdated on theirs, but let's see if we can find where the equality piece would come in to the prohibited conduct, maybe?
I mean, like I said, we can talk about this, if there's healthy, and I can send you everything that I get, as soon as I get it. It's just with everything going on with my dad, I did not have as much time as I would have liked to.
Yes, don't worry. Yeah,
Are you still recording? I think did that wrap after this week? Just the screen is now.
So mine is not linked to that, it's just your.
We're good on this.
Yeah.
And then I can send you things, and then I can just send you and be like, hey, what about this language piece, and see what you think.
Okay, all right.
But I'm sorry, this needs to be tabled. Thanks.
All right, so then we get into new business. We put that going forward. All right. Organize it somehow. We put that there. All right, so the first one that we had, these are all, and then you have DJC,
Yeah.
DJF, and DIC, right? So bidding requirements, is that the first one?
Yeah.
Okay.
So the one comment I had for DJC, after well, I guess it's the only sentence of the first paragraph. There should be language, and I'm sorry I didn't forward you any changes beforehand, but
I'm good on
there's
the
more.
No.
We should add a comma and say unless exempt from bidding requirements. Because it states that we should go through the competitive bid process for any of those thresholds, period. But that's not necessarily the case if there is an emergency situation, which is defined later. we don't go to bid, or if vendors are included on master pricing agreements or purchasing consortiums that are approved by the state of Rhode Island, we also don't have to go to bid. So I think just that sentence of saying unless it's exempt from the bidding process is important.
Okay.
Some of this stuff, some of the language in here feels a little bit procedural, which means like it's not necessarily needed, in my opinion. I have a question out to the purchasing department. Kayla's our purchasing coordinator today, so unfortunately she couldn't be here. But where it says all purchases below $1,000 are considered small purchases, and anything in maintenance or buildings and maintenance under $2,500 is considered small. I don't believe that's the actual practice. From my understanding, it's anything under $500 that we can pay without a purchase order. And so I think that those thresholds might be outdated. I could be mistaken, but I just want to clarify that with purchasing, which I should have an answer for hopefully before next school committee.
Okay, so would this be, technically it would change to 500, but how about for the purchasing of buildings and maintenance? Same? Okay.
But again, I just want to double check with purchasing.
Okay. Anything else in here?
Everything else looks relatively good. Oh, about the last sentence, fourth paragraph.
Fourth paragraph?
Yeah, it says the administration will make telephone contacts with 3 or more vendors and award to the lowest responsible and qualified bidder. And yeah, I think that can be removed. So this is basically saying in case of emergency, we would reach out to at least three different contacts to try to find a low bidder on the work. That I don't think in practice that's necessarily feasible all the time. One of the instances last year was a breaker went down at vets, and in practice, we're not going to call 3 different they're closed in a single day. If there's a qualified vendor that can provide those services, that's who we're going to go with because kids need to eat. So,
What paragraph?
so the one that starts competitive bid,
Yeah, okay.
very last sentence,
Oh, the last.
I think can be struck.
Okay.
That's not anything that's required by law or anything, unless it's just been put in here at some point through policy.
Okay.
And I don't think it's relevant. I think for this one, that was all I had. Everything else is relevant, is still
Would it be
good.
okay to strike the 1,000 and the 2,500 and put the 500, or you really want me to just hold off? And
I
just
think
go
we
through
should
it?
Yeah,
Okay.
we should check.
All right, I just didn't know if that would help me.
No, just
Highlight it.
highlight it.
Yeah.
Highlight it.
As to say like, hey, this one is not, just kind of like, so we can't get in trouble.
Which,
Just because the competitive bids, I was curious, do you think that's put in there to define, so there's no trouble, and things like, those very black and white.
Yes, I think so.
Right.
It's a check
Right.
and balance kind of thing.
You need this, you don't need that, you get, like, that's what I kind of was under it.
what do you mean? Can you explain a little further? Because it is a bidding policy, so everything in here should be related to competitive bids.
Yeah, but this one is, you said you don't need to put in competitive shall not be required. Is that the one? I'm just asking you.
Right, so that paragraph specifically is talking about the replacement of existing equipment. So that's The breaker would almost be like a good example. Like if a breaker costs $15,000 to replace, we don't have to go out to bid for it until it gets to that $20,000 threshold, unless it's an emergency. So maybe that's that example. But if we're replacing existing equipment of $20,000, we don't have to go out to bid. So that's what that paragraph is describing. But there are other exemptions from the bidding process, like pricing consortiums and master price agreements. So that's the only reason I want to add a sentence to the first paragraph, because it's more than just emergencies or the replacement of equipment. And I think we've recently put out like a little procedural memo about the bidding process that has more detail in it. And so I think one of the things we've talked about in policy before is that they should be broad enough to let the administration come up with like the procedures and the rules for following internally. So I don't think there's not a ton of need to spell out specifically master pricing agreement or anything. Like our purchasing department has those procedures and manages that process. So I think this should be as broad as possible while following state laws. Okay.
Okay. Any other questions for Brendan?
I don't think so, not for this one.
Oh.
This one was updated in 2019.
Oh, sure. Okay.
Everything's pretty broad.
All right. So then we have DJF purchasing procedure.
Yeah, this one, I don't have. changes.
Wow, look at that date though. Pretty impressive.
So,
Anybody forward? You guys are so young. Exactly.
That's what I think.
I think this is basically stating that whoever originates the requisition is going to be the person responsible for it, which is why the committee is that part of it speaks to the purchase order or requisition. So I don't know the changes here.
We could add their, reviewed and
Yeah.
it's today's date, so it doesn't look like we just hang
And
it
that'll
out.
go into that review folder, right?
Right.
Where's policies?
Reviewed, stamped, approved, stamped, approved.
Yeah. All right. And then lastly, we have DIT financial reports and statements.
So everything here looks good. My only comment is that I think, so the first sentence discussing a financial report that should be submitted to the mayor and city council within 90 days after the close of the fiscal year. In practice, that has not been done. I don't know the last time it's been done. But it has not been done the past couple of years. There's like an informal relationship there where I talk to the finance director from the city saying, based on our monthly financials, this is where it looks like we're going to end the year. But there's not a formal report that's submitted to them right now. It's not to say that we shouldn't aspire to have something like that 90 days after the close of the year. But I think Sean has brought up the point of meetings before, like, do we put the cart before the horse? Like, do you want that in the policy if we're not actually doing it in practice?
Right.
So I would say to strike that portion about the report shared with the mayor and city council within 90 days.
Should it just be reworded into?
Yeah, well, we just redid this, we revised it in March.
I think it was one of the ones that got reviewed without comment.
I don't know, because it says revised.
Usually it would say.
I think you were here.
I was at the meeting.
I think you were here at this table. And I think this is what we came up with. I mean, I did not bring my whole file of the policy. I mean, I could go back and check my notes.
So
Because it says revised, so we certainly did go over this and make any necessary revisions in March.
Is it really the wording of a prepared report and maybe it just reflects our real practices?
yeah, That's my only point, is that this does not follow current practice.
Yeah.
The audited financial statements are due at the end of, after 6 months after the close of the fiscal year. So that's regardless of however I would want this worded, or if we filed them late, it doesn't matter. They're due 6 months after the close of the fiscal year, so that language should remain. My question is just, do we include language about a report that hasn't been prepared in years for the mayor and city council, if we're not doing?
Can I ask you, the reason that you have those touch points with, the finance at the city level, what does that help us in terms of like, so I think that's what we want to capture in that policy, like that we don't want to just disregard any communication with the city, so whatever that looks like and the reason behind it.
Yeah, so I think the general tone of those conversations is to keep the city informed as to where we are the year, because they want to know, did the schools run a surplus or a deficit, by how much in either direction, because that helps the city on the planning side. So again, I don't think it's a bad idea to prepare a formal report 90 days after the
Well,
close.
maybe it doesn't have to be formal, but I would hate to say we're not going to keep them informed,
Right.
Whether that's communicating with meetings or,
Right.
I don't know.
And this, to me, sort of like gray area between policy and procedure, where I don't know if you define that report in a policy, or if we simply like start putting together a new report and say that this is the report that we send to the city 90 days after the close.
I understand that. That does make sense.
Just a timeline to strive for, but that was achievable.
Right.
We definitely want the 6-month thing to be the
It has to
policy,
be.
right? It has to be, but the other piece is more of a procedure.
Yeah.
All right, so in your opinion, you'd like to see that struck and then just start within 6 months, that can stay,
Yes.
correct?
Yeah.
And I'd like to review how we arrived at what this is, dated 3/12/24.
You have that, you said, right?
I'm gonna look through my,
Okay.
yes, and is there a way to check the history of the doc?
We
have to do it now.
Yeah, I'll have to look, because
Check
there
the
were
history.
history files, yeah. I can check the history of it.
What is that one that Anne would have touched though?
Well, Brandon was here because she remembered there were a couple of policies that you were invited to specifically because it had to.
Yeah, this would have been included in the other business office ones. So I'm not sure what was actually revised. I have to see the old version of it.
So.
But between now and then, I would say, regardless of what was changed before, just through reading it now, if that is not our practice right now, and it is something that we would do procedurally, I don't see why it's included in the policy. You're formalizing something that you're not doing, and so I just don't see why the language is there.
Great. So we are tabling the IGDB, and I'm going to communicate with our attorney about the language to make sure and give them the information that you shared with me.
Yeah,
and the
that's all I
ACL. And then we're gonna table Title IX and look a little more deeply at your other one. Yep, the district. We reviewed DJ. Wait a minute, I'm missing one. Am I not missing one? BIC?
Well, that's one of the main DJs.
Bidding requirements.
Bidding requirements, that was the one that we were going to look at, those two numbers, right? Okay. And then if that is changing, that'll go for a first read?
Yeah.
Okay. And then I think, DIC, I'm checking the history and you're checking your notes. But that said, I mean, I think your point is well taken, like it's not reflective of what we're doing. So as a committee, do we look at making that more accurate.
But I think we had that conversation
Yeah.
already in this, and we decided to go with this. So
Right.
I'm wondering what changed from March until today.
No. Hopefully those notes will say. All right. So that is everything that I have on here. We'll turn it back over to you for discussion and public comment.
Yeah, I will have it. Let's go first.
Yeah, just quickly, so my name is Jeremy Landry, I'm a second grader. Yeah, second grader in kindergarten at Workneck. I would agree with Ms. Kirby Chapman on the student publications that there's wisdom in making sure that if you can avoid having to do the work a second time, I think that that's smart, and so I think that's on point. I'm not entirely clear on the Title IX issue. The only recent change to Title IX is to protect transgender and gender nonconforming students, and I think that we should protect those students. And so I am aware that Westerly attempted to write a different policy reflecting its values towards transgender students, but that policy was in fact tabled and hasn't been brought back to the Westerly School Committee. So it's not a policy that's in effect in Westerly, probably because it violated state law, but I'm not sure. We'll have to check in with them. They do have a procedure on file, which is just a reflection of, again, it's very similar in terms of transgender students. It's very similar to the procedure that you have here in terms of what in fact you do when you have a grievance, right? So that's worth reading.
Yep.
But again, that falls right in line with state policy, federal policy. So I did check in with several of my colleagues at the ACLU. I know. It's right. It's good. It is what it is, right? So they did confirm that since 2018, it is Rhode Island state law that districts need to protect and and create equitable spaces for transgender, gender nonconforming students. So and our current policy on file does that. So we already have you already have approved, the school committee's already approved a policy which is in line with the state. So my view would be there's no reason to do anything about that because you are already in alignment. And again, whatever policy was developed in Westerly has been tabled there. So it's not, and that's why you can't find it. It's not in effect. Right. So I don't know if that helps. I'm not sure if that was what we're talking about, but the only recent change in Title IX is making sure we protect all of our students. And frankly, our transgender students are the most at risk. So we know that when we create equitable and secure spaces for them, that their outcomes improve and they thrive, right? And then when we don't do that, the outcomes are not good. It's a population of folks that I work with and are very important to me. So anyways, I just wanted to add that as you are doing your research because all that is out in the water. So I love policy. Thank you. There's like 2 people in the world that say that. The rest of you have to be here, right? Yeah. Thank you.
Okay. So next scheduled meeting will be October 1st at 4:30. Same time. And I already have a couple of more things that are coming to the table. I think we'll have another whole agenda. Okay. All right.
Motion to adjourn.
Second. Is there a second?
All those in favor?
All right.
Thank you for letting